Now, partition shall begin with second hearing. Petitioner, we have 803, and this one we have 802.
So the judges, I am speaking number 1 for the petitioner. Instead of in fact of the cases, there was in 2024, our elected Bombay has passed with important bill, which triggered restricted and forward publicity. In July 2024, our governor has been appointed. Thereafter, our assembly has passed 12 bills and sent to the governor for his assent. But he hold this bill and did not give assent or withhold or reserve for 18 months. This is absolutely considered as a pocket paper. In November 2025, after Supreme Court only, the governor withheld only 10 bills and returned that bill to the assembly for reconsideration without giving any message or reason why our bill is not considered. Thereafter, on 18 November 2025, we passed all bills in our assembly, and on 20 November 2025, we sent to the government for its assent. Thereafter, on 5th January 2026, the governor reserved that bill for during the assent. This is a paralysis of our federal system. This abrogate the law-making process of the assembly. As this is violation of the rule of law and which is the part of the Constitution of India. Your Lordship, in my first issue, whether pocket paper is a constitutional valid or not, under Article 200. Under Article 200 says can give three options to the government. First is to give asset, second is to withhold or return with reason or message to the assembly. Third is preserved for to reserve for the president. There is no fourth option as to keep silent. It is violation of rule of law and it violates the federal structure of the Constitution of India. As we made our 10 laws in the state list, which is mentioned 7 schedules of the Constitution of India. In the recent case, the state of Tamil Nadu versus Governor of Tamil Nadu 2025, INSC 481. Supreme Court repeatedly said that the pocket window is unconstitutional, illegal and illogical manner. Our bill should be assented as soon as possible. In my second issue, the Lordship, whether the government has absolute discretion to reserve bills under Article 201 after repassing. Your Lordship, no. In 201 particularly, it says reserved for 20. But in our case, our assembly passed that bill in the second time. So, in the recent case law, Supreme Court says that in the state of Tamil Nadu versus Governor of Tamil Nadu, the governor cannot reserve that bill as it is the illegal act. Because of that, that bill has been passed in the second time in this our assembly. So, our bills should be assented as soon as possible. Your Lordship, in our third issue, whether judiciary can prescribe time limit under as soon as possible, or does such a prescription violate the separation of powers? Your Lordship, My final submission is yes. Because judiciary must intervene if the asset timeline or withholding timeline is 18 months. It is a violation of rule of law if subrogate to taking process, and it violates the principle of federalism, supremacy of the federalism, which is the part of our basic structure, which has been settled in the case of the Brahmin. So, your lordship, our bill should be accepted as soon as possible and give a time. Thank you.
I take up medium also. My bill that yes, I need issues one to take. My it is 456. Issue number 4. Whether Article 361 immunity pass, the Supreme Court can issue a mandamus against the governor. No, my lord, because Article 361 is providing personal immunity. Personal immunity means also civil and criminal proceeding for government, not a mandamus. Why not mandamus filed against government? Because violation civil principles, some principles, rule of law, judicial review, and nature of justice. Violation for mandamus. This is some recent Supreme Court case Tamil Nadu versus state government, governor of Tamil Nadu, 2025. Court issues directions and held that the Article 361 does not bar a judicial review of governor of legislative council. And other cases as Sameshwar Singh versus State of Punjab, 1974. Governor is nominal head. He had advice for a legislative. This is number 5. Whether a governor must be retired with a message. When? With holding message. Yes. Article 200 constitutional power for governor without with message being rejected. But in these cases, this is not applicable. Why it is not applicable? Because nature and justice are highlighted, violations of nature and justice, violations of law, violations of legislative office. In recent judgment of 15 books, State of Tamil Nadu versus Governor of Tamil Nadu 2025, Supreme Court held that the simplicity will without basis in unconstitutional and dissent in the absence of fire. This is number 6. Whether the government can act as it was done and with the state law and treaty fiscal. No, your lordship. Governor not the supremacy of cost laws. Because governor act on a and advice council minister. Article 160 exposed in the such cases. He cannot take judgment of the populist law because it is violation of federalism. Nature and justice and democracy. When those are elected representative for previous recent case law, Tamil Nadu versus State of Tamil Nadu versus Government of Tamil Nadu 2025. Government cannot be assessed a was not elected a state of legislative which is void for federalism balance. State of Punjab versus Government of Punjab 2024. Governor is not a leader of property of elected or government, not a political leader. Your lordship, my humble fear that declare the pocket people simplicity with a that repetitive unconstitutional would all will give deals of asset from at the date of repetitions and issues for it a mandamus directing to the government against the timelines. I want
And then who comes with the 4-5. If you not do this, first was with the 8, but what is the first issue is whether the pocket is the actual governance then pending. Indefinitely, communicated as recognized power under Article. The petitioner alleges that the power in the pocket is related to the Constitution. While the Article 200 is very clear, the Article 200 of the Constitution provides the government only the Constitution to be recognized power. That is, withholding as granting an asset or reserving something for the there is no pocket bill or pocket bill. Although the petitioner's allegation is legally incorrect, saying the article and the second provides for the Article 200 does not prescribe any fixed time limit. There is only a phrase saying that the government may as soon as possible, which is a mandatory power. There is no mandatory that and any mathematical time bound that the governor has to have within that time. In this honorable court, it was held in first state of 1962, and the first was because that was the state of 1983. That was no timeline effect, but the court did not enter into an unresolved. And thirdly, in the present case, the governor was not pretty high. There was very fast, very short period of time. And each one was the national stability and the power of the High Court. And due to this constitutional stability involving fiscal stability and constitutional authority, that time taken by the governor is very reasonable. In the moment the honorable court expressed the government clear decision before us on 13 November 2025 and his response was constitutional and not unconstitutional indefinite. It will not reform it. May move to the next number 2. Whether the issue number 12, whether the governor possesses absolute discretion to reserve any bill for the petitioner's consideration regardless of whether it is the first or second time the bill has been presented. While the Article 200 expressly reserves that the government has free option. He may reserve the bill for the consideration of the president. And secondly, the second provides what the article also restricts full absent from the bill when it is recast and presented to the governor for the second. It is silent for the power regarding the reservation part. If we apply the principle of illustration, when the constitution is silent, but when the constitution is open for them, but stays silent for another one, we cannot think that another one is restricted by the constitution. But the government is full discretion whether it is for the first time or for the second time. And there was a second provision of Article 2 itself mandates the reservation when any constitutional question arises. When the power of the High Court is affected. And this honorable court in Shamsi saying that the state of Punjab, 1974 has said that the governor may exercise personal discretion power in the exception. The power is provided to the governor by the Article 200 of the Constitution. There is no specific bill submitted. The issue number answered by affirmative manner. Few lordship permits. May I rectify? So the issue number 3 is within the phrase as soon as possible is not there. Commit specifically prescribe a specific timeline for the geodax. But does the prescription it is no that absolutely that's what timeline for the government as the Constitution was deliberately given a flexible language consider
Geotech camera to it is geotech cameras. Okay, okay.
Secondly, the government's role in granting asset under
Geotech and so many partners.
it is a substantial specification of something given to the government by a constitution of any kind. The government must give the examine each and every case and each and every will that is presented in the game and has to consider that whether the will is constitutionally valid or not, or it becomes the business. And to state a fixed timeline for the government would undermine this important constitutional and thirdly, the Constitution clearly divides power of the executive and judicial. If the governor performs the constitutional function under the Article 200 by the Constitution, if the judiciary in the court enters into it and fixes the timeline, this might violate the principle of separation of power. That is the part of the basic structure as held by the Petitioner Arguments. And one of the Supreme Court has already recognized that rewrite the Constitution promotion in the Tamil Nadu Governor School. If the judicial part tries to fix the legislation, this would be one organ is trying to fix another organ, and this is like the separation of power. So yes, my lord, the judiciary, the governor's power of fixing a time would violate the separation of power. This is my submission. If you don't permit my
And second counsel, on behalf of the respondent, I shall address the issue number 4, 5, and 6. If you lordship permits, can I raise the issue number 4? So the issue number 4 is whether the personal immunity granted to the governor under Article 361 act as an absolute bar of the Supreme Court, issuing a writ of mandamus directing him to perform his legislative function. To deal with this issue, we first need to know what Article 361 says. As per Article 361, the governor shall not be answerable to any court for the performance and exercise of his duties of his office or for any act done or purporting to be done in the exercise of these powers. So Article 361 completely gives immunity to the governor from being answerable to the court for exercising the constitutional function. Secondly, what is writ of mandamus? A writ of mandamus is a comment by the judicial authority to a public authority to direct them to perform a particular constitutional or statutory duty. But if the court directs the governor to perform a particular duty, then it would violate the Article 361. The immunity guaranteed under Article 361 is embodied in the principle of res non potest speaker, which means that the sovereign authority cannot be answerable to the court for the act performed while exercising their constitutional function. This honorable court had held in the case of Rameshwar Prasad versus Union of India. It has held that the governor enjoys complete immunity under Article 67 and he cannot be made answerable to this court for doing his constitutional function. And another similar case is SR Mumbai versus Union of India. This honorable court refrained from directing the governor personally. Instead, it examined the matter against a particular government. The Article 361 does not altogether exclude judiciary. It does exclude directly the governor personally, but if a constitutional act is violated, then the proceedings can be done against that particular governmental authority, not against the governor person. So the relief which is sought by the petitioner by writ of mandamus is barred by Article 361 and it is not mandatory. If you not permit, may I proceed with issue number 5? Issue number 5 is whether a governor, once having been assent of the is mandatorily required to return the bill with the passage to the assembly, and whether the failure to do so renders it withholding of assent order in issue. My submission of these issues is twofold. Firstly, the Article 200 has two distinct parts. The first, the main provision says that when a state legislature passed a bill to the governor for assent, the governor has three options: either to assent, give assent, or within it, or to reserve it for the president. But the first provision said that if the governor wants, he may return it with a message as soon as possible. So the message provision is only available for returning, not for withholding. There is a distinction between withholding and returning the bill. And in case of also returning, it is not mandatory for the government. It is just a procedural requirement. The Honorable Court in the case of State of Uttar Pradesh versus Manipur Raj reversed the it has held that the word may ordinarily denotes discretion, not obligation, unless the context otherwise requires otherwise. But there is no context in Article 200. Also, similarly, there in the Bachavan Devi versus Northern Nigam that may normally means special and shall, if your lordship permit, may seek the court extension. And the petitioner argued that it is part of an issue, but in the case of State of Bihar versus Commission C, constitutional act is only part of an issue when it violates the mandatory constitutional requirement, when there is also mandatory constitutional requirement to provide massive regarding. So there is no question of part of an issue. If it also permit, may I proceed with issue number 6? Sir, on the basis of the factor and the circumstances of the case, the counsel on behalf of the respondent before this honorable court that it may be adjudicated and declared that the power which has been used by the governor has been equally valid under Article 200 and 201, and the rate filed by the state of Maharashtra is must be dismissed as being devoid of merit, and the mandamus is not maintainable because the governor enjoys personal immunity under Article 361. For this side act of the court, the respondent shall be duly found for it.
Now, in answer for the respondent, how can subsequent 18 months from channel side by acting what it gives only clear as to be clear out? That is African Gallery for already details of it is clear.
Answer. Okay. So the petition arguing that the doing this was critical. You yourself saying that it was a critical bill. So as the Constitution does not describe a someone mandate to the government, 18 months was enough for the government to examine study the complex issue which relates to these critical bills. As two of the bills mentioned, that is Maharashtra Agriculture and Dairy Bill, which includes a large financial burden, a large financial implication which would push the state into a larger burden And also, the minor and higher education, higher education government that introduced that removal of power of the executive chairman of the state university. So, it indirectly affect the power of the High Court by making this position political. So that's one.
Is this 18 months delay under policy? Yes, as possible.
This is quite subjective. So the 18 months because the delay was not completed. The government has been after it. So how you feel that evidence was completed?
As our bill has been rebuffed and recent has been invested. So that's report heads into Minister of Cabinet versus Governor of Cabinet. If a bill is said, the pass and reserve to the governor should not reserve or reserve. In our case, the governor reserve our funds.
After the repassage, reholding is valid, but reservation is not valid.
As important, there is no provision or no discretionary power lies of governor to reserve the bill after repass. In our case, our bill has been repassed in the Indian Assembly and thereafter.
But the bill doesn't connect. As per Article 200, the governor has some absolute discretion. I have taken